Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. Vocal crypto supporter John E. Deaton has hinted at what may happen if the U.S. Securities and Exchange Commission succeeds in its case against Ripple, the company that created XRP. Will Ripple be able to beat the SEC? The 2-year legal struggle between Ripple and XRP has been marked by significant procedural triumphs for Ripple, leading XRP fans to hope that Ripple would ultimately prevail. Annalisa Torres, the judge presiding over the case, may cause problems for many crypto-focused businesses if she agrees with the SEC's argument that all XRP transactions, including those on secondary markets, are securities. John Deaton claims that this is the case. According to Deaton, if the SEC wins, Chairman Gary Gensler will have the political support and momentum to file similar claims against other corporations in the digital asset area. In a tweet, Fox Business writer Eleanor Terrett offered some observations on the recent closure of Signature Bank, prompting the XRP attorney to respond. Significantly, the New York Department of Financial Services announced the closure of Signature on a Sunday with no explanation. According to Terrett, ex-Congressman Barney Frank's shrewd comments suggest that this was all part of a plan to convey a message against cryptography. One of the leading companies in the cryptocurrency sector, Ripple, has developed useful applications for blockchain technology. SEC's bombshell lawsuit against Ripple and 2 of its senior executives for illegally generating over $1.03 billion via the sale and distribution of XRP cryptocurrency in December 2020 devastated the nascent industry. The token's future hinges on the outcome of the litigation, which centers on the issue of whether or not XRP is a security. Crypto experts generally feel that Ripple is now ahead in the drawn-out legal fight. When the court declined to invalidate Ripple's primary fair notice argument last month, the SEC also suffered a loss. The judge's ruling, which is anticipated in June, will likely be a watershed moment for XRP and the cryptocurrency sector as a whole. Nonetheless, if Ripple is successful, XRP may challenge $1. In the ongoing legal battle between Ripple and the United States Securities and Exchange Commission, the SEC has submitted a response to Ripple's claim citing prior cases and their conclusions that may have an effect on the cryptocurrency business. According to a tweet posted by U.S. Defense Counsel James K. Filan on March 23, the SEC has delivered its answer to the 2 letters seeking additional authority from the bankruptcy case of Bitcoin lending platform Voyager Digital and the Bittner VED Digital and the Bittner v. United States lawsuit. As part of its fair notice defense, Ripple had previously filed the ruling in the Voyager bankruptcy case, citing Judge Micah Wiles' comments on the significant uncertainties in the cryptocurrency industry, on which regulators themselves cannot seem to agree. The second letter addresses the case of Bittner v. United States, whereby a U.S.-born citizen of Romanian descent neglected to declare all of his income to the Internal Revenue Service. Fair notice should be provided to the public in terms that the common world will comprehend of what the law plans to do if a specific boundary is crossed, the court said. The SEC has responded to the defendants' letters, claiming that the reasons raised in them do not constitute a valid fair notice defense and that neither offers any basis to reject the SEC's petition for summary judgment. The SEC has moved for summary judgment, and the defendants have sent letters citing stray words from 2 instances in objection. Defendants argue that these passages buttress their fair notice position, but none of them is correct. The SEC's legal team argued that the court's decision in Bittner, which addressed whether penalties could be imposed once for each unreported foreign bank account or as a single fine, supported its position that a single penalty could be imposed for the transgression under the rule of lenity, but did not imply that the rule could be used to escape liability. Summary judgments, a settlement between the parties, and a follow-up litigation exploring whether any XRP token sales in the U.S. contained an unregistered investment contract are all possible outcomes previously cited by former attorney and Evernote XRP co-founder Scott Chamberlain. Judge Analisa Torres issued an initial 57-page ruling in which both the blockchain company and the financial regulator were seeking to exclude expert testimonies from summary judgment, and his recommendations came after what he believed to be a major win for Ripple against the SEC with the fatal exclusion of one specific witness. Ripple Chief Legal Officer Stuart Alderoty has responded to Coinbase receiving a Wells notice from the U.S. Securities and Exchange Commission, SEC. A Wells notice is a letter issued by the SEC expressing the agency's view that a corporation or person has violated securities laws. Significantly, it permits the receiver to react to these assertions in order to persuade the market regulator that they are false, with the SEC having 6 months to determine whether or not to pursue an enforcement action. Coinbase verified receipt of this letter from the SEC yesterday, but according to a blog post written by Coinbase's chief legal officer Paul Grewal, the letter provided insufficient information for Coinbase to reply to. Coinbase emphasizes that the possibility of enforcement action comes despite the fact that the SEC cleared its operation and permitted it to become a publicly listed company in April 2021. Only days before SEC Chair Gary Gensler took office based on these same disclosures. Moreover, the company said that it had met with SEC authorities 30 times in the previous 9 months in order to register a component of its business and settle inquiries. Nevertheless, the SEC, which first proposed this strategy, terminated the process in January after Coinbase claimed to have spent millions of dollars in legal expenses to identify viable registration models, since none exist for cryptocurrency under the current system. According to recent reports, the cryptocurrency exchange seems to have been preparing for a clash with the regulator in recent months. As previously reported, the crypto exchange updated its risk notice to state that it may elect not to remove a listed crypto asset, even if the SEC labels it a security, barring a court judgment in favor of the regulator. In a tweet today, Alderoty seems to back the top cryptocurrency exchange, citing the old saying, "The enemy of my enemy is my friend." Moments afterwards, the Ripple Clo retweeted Grewal's answer to the SEC's Wells notice. Ripple is still embroiled in a legal battle with the market authority over whether XRP is an unregistered securities offering. Coinbase filed an amicus brief in favor of the blockchain payments company's lawsuit, which it framed as an assault on the whole young sector. According to Consensus lawyer Bill Hughes, we should expect a flood of amicus papers in favor of Coinbase if the SEC decides to pursue an enforcement action. Based on Alderoty's comments and other precedents, it would not be strange to find Ripple among Coinbase backers. Nevertheless, Hughes believes that if the SEC pursues enforcement, the prospective court fight would go for years, well beyond Gensler's rule. According to the attorney, this will most likely arise from factual disagreements, allowing it to go to appeal. In a subsequent tweet, the attorney said that supporters of a free market system would be disgusted by the SEC's actions. The future of the nascent market in the United States remains unknown. After the failures of Terra and Fox, authorities, notably the SEC, seem to have initiated an industry-wide crackdown. Market players, on the other hand, continue to ask for unambiguous market advice.